SJC-10630, Commonwealth versus Morgan.
Hey, good morning.
Morning, Counsel.
May it please the Court, my name is Steve Nyman. I represent
Mr. Nyman, wait just a second for the clerk to start the clock.
Thank you.
Trying to get that extra minute. This is a case that goes back to 2006. And 4th of July 2006, Alberto Cintron went into his house shortly after 2 o'clock in the evening. It was an apartment in Lowell, Massachusetts. He went with a fellow by the name of Curtis Glenn, and as soon as he got into the apartment, he realized that something wasn't right because his dog would usually come out and greet him. Within what appears to be just a second or two, a couple of masked men came out demanding money, and shortly after that, gunshots were fired. Mr. Glenn got down on the ground almost immediately. He was able to make observations that the two men who were involved were about 5 feet 7 inches tall. He got into a bathroom window, actually knocked the window out with his head, jumped to the ground, and took off, and was met by police shortly after, and provided a certain amount of information. This case was initially went to trial on the defense theory of there being a third-party culprit, and a lot of that stemmed from Mr. Cintron's statement during a 911 call that the assailants were Chris, being Christopher Middlemas, the co-defendant, and an Asian kid. Defense counsel made a strong effort to get in some information about a fellow by the name of Jesse Doe, and there was a voir dire, and I should probably backtrack just a little bit. The Commonwealth made the bulk of its case through the testimony of two cooperating witnesses, a gentleman by the name of Scott Russell and someone else by the name of Ferderer. Both of them were accomplices, at least in some regard. Ferderer brought guns down from New Hampshire for what appeared to be, initially at least, an attempt to rob Mr. Cintron. Russell agreed that he would be part of the getaway team, and according to Russell and Ferderer, Middlemas and Morgan were going to go and rob Cintron at his apartment. They had access to it. They had a key because a friend of theirs by the name of Jesse Supernault was friends with the victim's girlfriend and was able to gain access. Apparently, the story is Russell and Ferderer would have it was that my client Middlemas went into the apartment beforehand but were unable to find any money, so they waited until Mr. Cintron got home, where they tried to effectuate the robbery. In any case, getting back to this to the Asian kid, there was a gentleman by the name of Jesse Doe who was an accomplice of all of these people. Jesse Doe was an Asian male. He was about 5 foot 4 inches tall, which is much closer to the description of height given by Curtis Glenn than what Mr. Morgan's height is in actuality, which is about 12 inches taller than that.
But the jury, or the judge, allowed in evidence that Mr. Doe was an Asian male, that he was present for discussions regarding the robbery of Cintron, and that he actually accompanied the defendant in Middlemas in car theft activities. So the only thing, as far as I can tell, that he did not allow in was that Doe had been robbing people at gunpoint in May or June of '06.
Which fit the same pattern as the crime in this particular case and sort of the events leading up to the crime. Initially, the plan, I use the word loosely, was earlier in the evening. The plan was to rob Mr. Cintron outside of the bar that he was at. I think there was some discussion that perhaps that wasn't going to work out the way everybody planned, so Plan B was to go over to the apartment. It was Doe who had actually been robbing people at gunpoint. He'd jump out of cars. He'd rob people at gunpoint. He'd use a .22 or a 9mm.
Right, but that's
Doe also stated
that's a different MO, isn't it, from what was actually done here? It's a different caliber of gun, a different style of robbery.
Well, no, there was only one different caliber of gun than there was a 9mm, so it was a .22 and a 9mm. it was a different style. I'll concede it was a different style of robbery, which actually gets into another issue here, which we can either take up now or in a moment. But, well, I guess we should probably take it up now in the sense that the judge admitted prior bad act evidence that pertained to Morgan that came from Scott Russell, who stated that my client would break into cars, steal items of value, go out and sell them, and that he was also engaged in selling marijuana. That, first of all, never should have come in. I'll address that in a second. But insofar as the third-party theory, I guess part of my argument was if that material was good enough to come in against my client, and I submit it was for prior bad acts, even though the judge said it wasn't, certainly it would fit the same logic that you'd be able to get that information in about Jesse Doe and apply it to the defense in the case.
But they came in a little bit differently. I mean, the statements you're describing, I guess, came in through Russell's testimony, I think, and that Russell said that the defendant had been supporting himself for breaking into cars and stealing stereos, and there was no objection, and the judge sua sponte gave a limiting instruction.
I think there was some discussion prior to trial during motions in limine.
Oh, there were.
To the best of my recollection, I apologize for not making that more clear here, but that is to the best of my memory. So there were discussions about excluding these things earlier.
So you're saying it was objected to in a motion in limine?
I think it was raised in a motion in limine. I don't think it was objected to at the time it came up.
I know that. But you're saying there was a motion in limine?
Yes, that's the best of my recollection right now, and I apologize for not incorporating any of that in the brief, and I'm not really sure why I didn't.
Well, you can add it in the 16L letter if you want.
Right, thank you. Something in that regard just escapes me right now, but it's usually when I read my things, they make an awful lot of sense to me. It's only when people remind me.
We all have that problem.
But in any regard, I kind of want to stay a little bit focused here. That really was the defense in this case. It was a third-party culprit defense, and defense counsel was cut off, and he should have been permitted to extend it and let the jury make the decision in that regard. I raised another issue relative to voluntary intoxication, and the Commonwealth made what is typically the salient point that we're trying to change defenses after the fact. But you have to understand that defense counsel was proceeding with this third-party culprit theory, believing that it was going to be viable and believing that he really had a very strong defense where the victim in the case identifies an Asian kid, and he knows...
To make that argument to the jury, didn't he?
Yes, he was able to make that argument to the jury.
And if I understand you, what you're saying is you weren't allowed to get in all of the arguments you wanted to make about third-party culprit, but the judge did allow in some of the information about this alleged third-party culprit.
Well, I think
Is that right?
it is, but the prosecutor made had a very clever examination of, I think it was the medical examiner talking about the deprivation of oxygen to the brain as the blood starts to escape your body. These are really gross generalizations because I wasn't really focusing on that for the purpose of this argument, but in essence, enabling him to argue to the jury, look, that comment about an Asian male, this was a guy who was dying, he was losing the blood, and it just wasn't a competent comment at the time. And it was a good argument. When it was based on evidence, it was appropriate. But if defense counsel was able to get in that information about Jesse Doe and who he is and his relationship to these parties, and the suggestion that would extend from that Alberto Cintron, the victim, knew Jesse Doe and thereby made his identification of Jesse Doe without using his name, just an Asian kid, and Christopher Middlemas. And that's a lot more compelling to a jury when you have the whole picture in front of them than when you just let in, well, he said it was an Asian kid, and then the prosecutor is able to take that and say, yeah, but he was losing his mind, he was dying. He really wasn't able to make a very clear statement during his 911 call. And that's probably more understandable to a jury.
The part you wanted to get in was that Mr. Doe was involved in robberies and used a gun. Correct?
That he was involved in robberies, that he used a gun, that he had spent the previous 2 nights in the downstairs apartment where Mr. Russell had been, and that...
He wasn't allowed to get that in? That he had spent the 2 nights downstairs?
It just didn't come up. I mean, was he not permitted
Well,
to?
the judge didn't say you can't go into that.
No, he didn't, but he made his limitations, and I tried to actually detail them as best I could. It's October 20th, 2008, that volume, the transcript pages 116 and 117, that you can offer evidence that Doe is an Asian male and evidence that Doe was present when there were conversations relative to robbing Cintron. So that's his ruling, and defense counsel accepted it. And I can't really speak for defense counsel, but typically when a judge makes a ruling, there's a couple of ways you can handle it. Number one, you can fight, and you can fight to the point of being obnoxious, and chances are pretty good. 90+% of the time you're going to lose them, or you can accept the ruling. And I think this is a very seasoned, professional, excellent defense attorney. I think he accepted the ruling and moved on. He objected to it. He made his record. They had the voir dire, and you have to understand the judge. This came up twice, and the judge stuck to his ruling both times. It came up first after the voir dire, and then the judge said, I think I'm going to have to wait until this sort of materializes at trial, and then we'll revisit it. And when they revisited it, it was the same. It was the same ruling.
Part of the proffer, counsel, that there were conversations, though they didn't directly relate to the Cintron robbery. Is that what you're saying? I'm a little confused by what you.
No, there was a.
Had that been suggested, that could have been part of the evidence? It wasn't just the robberies, that you mentioned that specifically, but also that there were other conversations with all the people present, even though those were not specifically relating to potential robbery of Cintron?
Sure, but how do you then make the next step and attribute?
No, I just wanted to, that was a
Yes,
question.
okay, yes.
Yes, there were. There were those. That was brought to the judge's attention that could be potentially the evidence that he wanted to present.
Well, just that Doe was present when there were discussions about Cintron being robbed, but if you can't extend that to the proper, and he did use it, conversations in the plural, but I'm probably not understanding your question.
Okay, we can check.
Well, the judge said
transcript. Go
that
ahead.
could be presented to the jury. Am I right?
Yes.
Okay.
But you still can't, but then
Am I
what you're...
correct also that the judge allowed in that Doe was present with the defendant in Middlemiss when they were engaged in car thefts?
Yes.
Now, of course, that cuts against your other argument, because to get that information in on Doe, you'd have to get in the information that the defendant was involved in the prior car thefts.
It does cut against that argument, absolutely, and and I guess what I'm trying to put out, or put before the court, is there's this certain inherent inconsistency in the judge's rulings that just patently unfair in that regard. On the one hand, he says you can get this bad act evidence in against Morgan, and then but you're right. I mean, to extend the Doe thing, obviously that would come in. If I can focus on that bad act evidence again, though, that was unnecessary. That was superfluous. And that wasn't one of those situations where you have to explain, like why did this happen? There was no need to get into all these prior car breaks. There was plenty of evidence that suggested what this crime was all about. It came from Ferderer. It came from Russell. It had to do with an intention to rob a drug dealer who these people knew. They lived downstairs from him. They knew what bar he was going to. They had access to his apartment through keys. They called one of the accomplices to come down from New Hampshire and bring a gun, and the other accomplice and cooperating witness was part of the getaway team. You didn't need to get in all this stuff about his prior bad acts and to say what a bad guy he was. It was inappropriate. And it also was not accurate the way it was instructed. At least that's my contention, because the instruction focused on motive. I mean, if anything, that wasn't the motive. It was more a pattern of operation or a common scheme. And it's important when you're instructing the jury that you make that distinction, and the judge didn't make the distinction. And here's probably the most compelling part of my argument, at least in this regard, is that the judge continued that the motive dealt with the predicate felony, that the felony to complete the felony murder. And that's what Mr. Morgan was found guilty of, felony murder, not any other theory. So it hurts in that regard even more. If I can just briefly talk about, well, I don't know how much longer I have. Hopefully it's
You
much.
have 4.5 minutes.
I guess it is briefly. If I can get into the Rosario issue really quickly. You know what, I find this a very, very troubling issue. I think this comes up more often. There's a rule in place now, and that's that rule: you get into court the next day, there's a certain amount of time, and you get in and get arraigned. And it's my contention that regardless of what the officers intended in this particular case, there is so much room for abuse when you say things like, we have to just wait till 10 o'clock till the major print guys come. Joseph Morgan was not somebody who had been involved with the criminal system before. He hadn't been Mirandized before. He was 21 years old. He didn't get what was going on, perhaps. He'd already made a couple of inconsistent statements to the police at 9 o'clock the previous night, at 1 o'clock in the morning when he was arrested. Someone in that position is going to be thinking, I just have to say something or I'm never going to get out of here. And that's the point of Rosario.
But he signed the waiver.
At 11 o'clock.
But it was before he
At 11 o'clock in the morning. Court opens at 8:30. And you know what? On these murder cases, as this court well knows, I mean, once the investigation is wrapped up and you have an arraignment coming the next day, the committee is called, the calls are made. As a matter of fact, there's evidence here, but Captain DeMora had to come and break up that final interview because Bob Griffin was already appointed by CPCS and got down there. So they can fool around with this all they want, but the more a court says, any court says, well, I'm going to give you, the extra 2 hours. That's okay. We're going to wait for major prints. What's the next step? Well, when are you going to wait? 3 hours, 6 hours?
But if you look at it the other way, do you suggest that you shouldn't, you have to have the waiver at the beginning? I mean, if he signs a waiver, what are we supposed to do with that?
Well, no, he signed the waiver after. I mean, the waiver, there has to be something contemporaneous about the waiver and the opening of court, or nearly contemporaneous. Not, let's see how much he can take. Let's see if he can take, another 5 minutes. Can he take another 2 hours? Let's leave it out there. Let's leave it out as a big question in his mind. What happens next? Well, they've interviewed me twice. They let me go once. Then they brought me back. Then they arrested me. Now they held me overnight. Now at 8 o'clock in the morning, Detective Latham walks by me, doesn't process me. I'm not brought over to court. Court's open. It's the day after the holiday. And now it's a couple hours later. Now they're going to take my prints. And after they take the prints, let's go and have a discussion at 11 o'clock. Let's sign the waivers. And then now we have to interrupt you 20 minutes after that because your lawyer's here. We can't talk to you anymore. It just doesn't, it's not right. It's not the way Rosario was meant to be. At some point, there has to be a cutoff. There can't keep on being excuses and exceptions under any circumstance. It's a rule. It has to be adhered to, or it sends a really bad message to law enforcement saying, we can toy with this guy just a little bit. We've got him on the breaking point right now. And keep in mind, he confessed during that last interview, not the previous two. And that was really troubling. If I can just, I don't usually argue this issue, I raise it, but the 33E review, if you look on October 21st, 2008, page 76, there was a statement that Russell made that when Middlemas got in the car, he said that Morgan had, when he was initially in the apartment with Morgan, Morgan had gestured for Middlemas not to fire. So implicit in that is he didn't want this to be the result. And I understand that the felony murder rule contemplates felonies going too far and there being a killing, but in this particular case, at least before Cintron was shot and killed, Morgan tried to get Middlemas not to fire. But he did, and he bragged
But I
about it.
gather there were shots fired by both guns.
There were shots fired by both guns. It wasn't made super clear during the trial, but I think what you can extract from this is that there were 6 shots fired altogether. 4, if you believe Ferderer, and if you believe that the guns that he passed out, these parties never exchanged, and just used the ones he gave them, 4 by Middlemas and 2 by Morgan, and Commonwealth and I have a little bit of disagreement. Commonwealth believes that Cintron was shot 4 times. I think that Richard Evans might have said he was shot 5 times, just to be candid with the court, which would mean that one of Morgan's shots did strike him. If it didn't, I can always make the argument that the other 4, then if it was only 4, came directly from Middlemas.
Your time is up.
Yeah, thanks a lot. Thank you very much.
May it please the Court, my name is Casey Sylvia, and I'm Assistant District Attorney for Middlesex, appearing on behalf of the Commonwealth in this matter. Your Honors, first of all, the motion judge properly denied the defendant's motion to suppress based on alleged violation of the defendant's rights to prompt arraignment under Rosario. The evidence of the motion hearing proved that the defendant knowingly, intelligently, and voluntarily waived his right to prompt arraignment. And I think what's significant here is that he waived his right to prompt arraignment before he gave that statement. So it's not...
He did, but what do you say to Mr. Nyman's argument that if you just keep holding them, I mean, that the underlying thrust of the rule is to get police to bring the person to the court as soon as possible? I mean, so that 11 o'clock isn't as soon as possible.
Your Honor, this court in Rosario made it clear that that a defendant can waive his right to prompt arraignment at any time. And I think that the reason for that, and of course it has to be a voluntary waiver, which is what I think alleviates Your Honor's concerns about holding somebody until the point where they just give up and they say, okay, I'll tell you whatever you want. Because that does have to be a voluntary waiver, so I think it addresses that concern. But I think there's a good reason to allow for a waiver beyond that 6-hour period. And actually, I can think of 2 good reasons. One, from the perspective of the Commonwealth, that homicide investigations are lengthy affairs. Information is constantly developing. Sometimes it'll take us 6 hours when I'm at a police station to do just a search warrant.
Okay, but why not get the waiver at 8 o'clock in the morning or at 8:30 in the morning?
Prior to interrogating the defendant? I think that...
No. Before you have to take him to court.
Well, I think that this court in Rosario said that it wasn't relevant whether or not court was in session or whether it wasn't in session. I think it's better practice to give the defendant his Rosario rights before you speak to him, as close as time impossible to when you speak to him, to be sure that he really does want to waive his right to prompt arraignment. Because otherwise, if you're doing it 8 in the morning and you want to talk to him at 11 a.m., it's not clear that he's going to remember what he was told at 8 o'clock a.m. Also, the other reason I can think of from the defendant's perspective why the 6-hour rule, why it shouldn't bar all statements in any waiver past the 6 hours is because some defendants do want to speak to the police. They want to exculpate themselves. They want to explain their side of the story. And if you look, for instance, at Scott Russell and Colin Federer, their decision to talk to the police was a good one. They got their charges reduced down to manslaughter, and they got 7 to 10 years. So it's not always a bad decision to speak with the police. And there are defendants that choose knowingly, intelligently, and voluntarily to speak to the police, and it turns out to be a good decision for them. When it comes to this defendant, it turned out not to be a good decision. It turned out not to be a particularly smart decision, because he essentially confessed to felony murder, although he didn't realize he was. But that doesn't mean that legally it wasn't an intelligent decision. It doesn't mean that we should be exercising some type of, that we should be substituting our judgment as lawyers for that of a defendant who wants to speak with the police, because we know that perhaps it's not a particularly good idea for him to speak with the police because he doesn't understand what the felony murder rule is. So I think from both perspectives, there's a good reason to allow for a waiver beyond that 6-hour period. And I also just want to point out the motion judge in this case had before her not just the written waiver of the Rosario rights that the defendant had signed. She also had an audio recorded waiver of the defendant waiving his Miranda rights and the defendant waiving his Rosario rights and the defendant reading the first paragraph of Rosario aloud just to ensure that he could read before he signed that waiver. And he does that all on audio tape. So the motion judge had the opportunity to evaluate his tone of voice.
And what time was that?
That was approximately 11 o'clock a.m.
And when was he first arrested?
He was arrested at 1:20 a.m. He was brought for major case prints at sometime after 8 o'clock a.m. and at 10:59 a.m. He was brought back from major case prints at between 10:30 and 10:45. One of the officers said to him, do you want to talk to us now?
So when do you say the waiver should be, or the police should try to get a waiver?
I mean, I think
After 6 hours, can they wait 7 hours to try to get the waiver?
I think it just should be before they speak with the defendant. And it might be that there are situations in which, if 26 hours have gone by, maybe at that point that bears on the voluntariness of a defendant's waiver. But here you're talking about the Rosario period would have expired at 7:20 a.m. and he waives his Rosario rights at 11:02 a.m. That's when he signs the waiver. And he's brought to Lowell.
When did the rights attach?
I'm sorry?
When did the Rosario rights attach?
They attached at 1:20 a.m. when he was arrested.
Okay, so 6 hours later.
At 7:20 a.m.
They should have brought him to court, or if court was open, but if court wasn't open, court opened at 8:30.
Yep, that's correct.
So why not get why don't we say that they should have obtained a waiver from him at 8:30 in the morning?
Your Honor, I don't think, well, like I said
Just
before,
tell me why not.
I think it's not a good idea to give these people these rights before speaking with them or before even intending to speak with them because of the possibility that when they do decide to go interview the defendant, that he's not going to remember. It's not
So
going to be at the forefront
should
of
we
his
get
mind.
Miranda warnings after the person confesses?
Oh, no, and here the defendant was given his Miranda warnings and his Rosario
no.
warnings before.
But he wasn't given his Rosario warnings in a timely manner.
Your Honor, he wasn't given them within the 6-hour period, but this court has never said, and I would suggest that it shouldn't say, that those warnings have to be given within the 6-hour period. Having said that, he was also Mirandized twice before the night before, and because those two statements weren't an issue, it's not clear on the record whether he was given his Rosario rights at that time, but he may have been.
He had a right to be brought to court at 8:30 in the morning. Why didn't the police get a waiver from him at 8:30 in the morning?
Because of the fact that at that time they didn't intend to speak with him. And so, I think...
So then why didn't they bring him to court?
Because of the fact they need to do major case prints, and they were waiting for the state police technician to come to do the major case prints.
They can get those afterwards.
Well, Your Honor, I tried to suggest this in my brief, and I'm not sure whether I was clear about it, but I don't think there's anything wrong with the Lowell police. I don't think there's anything unreasonable about the Lowell police wanting to get the full, complete case prints of someone who's accused of murder.
You can get those after court.
But my point is I don't think that it's unreasonable to want to get them before you bring him into a public courthouse. I mean, every time you take somebody out of lockup, you're running the risk of them, they're being exposed to the public. You're running the risk of them escaping, potentially.
So if the fingerprint people called and said we were just in an accident, we can't get there until 3 o'clock in the afternoon, what do you do?
I mean, that might be a circumstance where, that's not the circumstance here, but if that were the circumstance, maybe that would be a reasonable delay. But that's also not what Rosario says. What Rosario says is that the statements are not to be excluded for unreasonable delay in arraignment if the defendant executes a waiver at any time. And so I would suggest that this was a reasonable delay, but even if it were unreasonable, Rosario says that a waiver can cure that.
If I could just stay with the confession for a moment, I gather he refused to be tape recorded.
Yes, Your Honor. He only agreed to the
apart from the Rosario and the Miranda.
Yes, Your Honor.
Was he entitled to a DG and Batista instruction? Because he didn't get one.
Your Honor, I did notice that when I was looking at the jury instructions this morning. One was not requested. Whether or not he would have been entitled to one, I'm not sure whether that's clear. But I did notice that this morning. As I say, there was no request for one. So I don't think that it was really a live issue at trial because of the fact that his decision not to be audio recorded was actually recorded itself, and that was entered in.
But voluntariness was addressed by the motion judge in her ruling.
Yes, it was. And the trial judge also gave the humane practice instruction. He just didn't give the DGM Batista instruction. To the extent that the defendant may have been entitled to that, I don't think that it raised any substantial likelihood of a miscarriage of justice in these circumstances.
Is it your view that when a defendant says, I don't want to be tape recorded, that he still is entitled to that instruction?
I'm not sure whether that's clear, Your Honor, from the case law. My position would be at that point, when you make the decision not to be recorded, and you put that on audio tape, and you sign a waiver, I'm not sure that you should get the benefit of the DGM Batista instruction at that point, because it's not that you weren't given the opportunity to be recorded. You decided not to take the opportunity to be recorded, and that's very clear on the record when your signature and your voice are before the jury declining to have the interview recorded. And that basically you'd be gaining a windfall from that instruction.
It's a cake and eat it too.
Exactly, Your Honor. Exactly. I'd just like to turn to the third-party culprit evidence. The Commonwealth's view of that is that the trial judge acted within his discretion in allowing the third-party culprit evidence that the supposed third-party culprit, Jesse Doe, could have committed the crime. And that consisted of the cross of two of the Commonwealth witnesses and the defense counsel arguing to the jury in closing that Mr. Doe was, in fact, the Asian male that the victim referred to when he was lying on the floor dying.
I guess I'm confused as to why the judge didn't allow in what Mr. Nyman is talking about.
Right,
What was the rationale for not allowing in the robbery part?
I just want to be clear about what was allowed in, because I think that there was some confusion on that previously. What was allowed in was the fact that Jesse Doe was Asian,
Yep.
that he knew the defendant and Christopher Middlemas, that he was present when there were discussions of robbing a drug dealer, and that turned to discussions of robbing this victim, that he was present when the guns were passed around that were used in the commission of the robbery, and that he slept over the night before. That also was admitted into evidence. And I think this is very significant. The judge would have allowed in the testimony that Jesse Doe also participated in those car breaks with the defendant, and defense counsel apparently decided he didn't want that evidence in. And last night when I was going through the transcript, I found that, in fact, the judge would have allowed it, and the Commonwealth instructed its witness not to mention the fact that Jesse Doe participated in those car breaks at defense counsel's request. And that's at transcript volume 7, page 12.
But didn't defense counsel object to the car breaks coming in?
He did. That's my guess as to why he didn't want the evidence regarding Jesse Doe.
And what, maybe you could turn to that. Why was the car breaks relevant to this case?
Your Honor, I think it was, and the trial judge was clear that in his view that this was relevant to the defendant's motive. It showed this need for money, well, with all the other evidence, Your Honor, because of the fact that the evidence came in this way. The defendant was unemployed, and his means of gaining money was stealing from other people, breaking into cars with his friends. And as his need for money grew, he needed to find a new plan, because he wasn't getting enough money from stealing things like CDs out of people's cars and pawning them. So when Ms. Supernaut starts leaning on him for rent money, he needs to come up with a new plan. And the new plan that he and Christopher Middlemas come up with to get money, because of the fact that the way they get money is by stealing.
Why couldn't you just say he needed to come up with a plan? I mean, what does it add that he used to get money in this illegal way, but now he's switching to a new terrible way? I mean, I don't.
Your Honor, I think I'm sorry. I think that it paints a full picture of the events for the jury, and I'd suggest that it's very similar to Commonwealth v. Bradshaw, which I cited in my brief. That's 385 Mass 244, and it's a 1986 case. And in that case, the court said that it both showed motive, intent, and painted a full picture of the events for the jury to admit evidence that a defendant had this escalating need for money across a period of time that finally culminated in the death of the victim at the end of this day. And I think it's the same thing here, that it shows that the steadily escalating extremes that this defendant is willing to go to get money. It's part of his desperate search for money, which finally culminates in the death of Alberto Cintron. And I think it is very similar.
But that cuts both ways, in that Mr. Nyman can say, if it's relevant to the motive of Mr. Morgan, then the armed robberies that Mr. Doe had committed were equally relevant to Doe's motive as the third-party culprit. So How come it comes in for one but not for the other?
Well, Your Honor, it's actually, again, the trial judge would have allowed in exactly the same testimony with regards to Jesse Doe, that he was doing these car breaks with the defendant and Mr. Middlemas. So he would have allowed precisely the same testimony for the third-party culprit.
Did the defense counsel decide not to proceed with that before or after he knew that the car breaks as to his client, that is, this defendant, was going to come in?
After. It's in between witness testimony. It's the beginning of transcript volume 7. So it's after the point where he knows that evidence is going to come in against his client.
And he still objected to it coming in as to Doe?
Yes, and that's the Commonwealth. The prosecutor stated on the record that he needed to go speak with his witnesses because defense counsel had told him that he didn't want that evidence coming in regarding the car breaks and Mr. Doe. And because there's no motion for a new trial, I can't really speculate too much with regards to what his reasoning might be, but as Justice Botsford said, my best guess would be it's because he was objecting to that whole line of testimony coming in regarding the car breaks because he thought it was prejudicial to his client.
That, I guess, leads to my question. Had he objected? Was there a motion to eliminate a Bard?
Yes, Your Honor.
There was.
It was argued by defense counsel. There was no objection at the time of the testimony coming in. Having said that, I believe that the judge said that his rights were preserved on this issue.
From the motion in limine.
Yeah, that's my recollection. With regards to the armed robbery, as Your Honor inquired about, the reason that it's not relevant to Jesse Doe's motive is because of the fact that there's no evidence of what his motive was to do those armed robberies. In fact, it appears from an offhand comment by Scott Russell during the course of the voir dire that, in fact, it may have been something gang-related, which had also been barred from coming into testimony, anything gang-related. And because of the fact that it's not relevant to Jesse Doe's motive, it's not relevant for any purpose. It's different than the motive evidence that came in against the defendant, which wasn't just he'd been breaking into cars. This was a part of a whole course of conduct. This is the way he was supporting himself, because he was unemployed, because he didn't have money, because he needed money, and this was how he got money. It was from stealing from other people. So it wasn't isolated evidence the defendant's a bad guy, he breaks into cars. It was evidence taken in context that he was somebody that needed money, and this is how he went about getting money. And as his need escalated, so did the extremes he was willing to go to. And so I think it's different than the evidence about Jesse Doe, which would have been simply, Jesse Doe told me once that, he'd been jumping out of cars and pointing guns, maybe a .22 or a 9mm, at people and relieving them of their belongings, I think is how it was put. That would have been the sum and substance of that testimony. It took place at some unspecified point in time, perhaps a month or two before the murder, but there's nothing to show what Mr. Doe's intent there was or his motive was. So I think it stands on different footing from the evidence that was admitted against the defendant to show his motive. I also just want to point out that the armed robberies they're not similar crimes in the sense that they're not strikingly similar. They're not what we might call signature crimes, which this court has addressed in cases such as the Kaiser case or the Conkey case, or, for instance, the Harris case. And I think the Harris case is particularly instructive because of the fact in that case you had crimes that really were, to the layperson, very similar. There were a series of rapes. They involved a woman being raped at knife point. The assailant threatened to kill her, and he was wearing a leather jacket, as was the accusation against the defendant. And this court said that the judge didn't abuse his discretion in not letting that evidence in because of the fact that those crimes were dissimilar. So if those crimes were dissimilar, these crimes certainly can't be so strikingly similar that this evidence should have been admitted in the interests of justice. And finally, I just want to say that to that point, that justice did not require a different result in this case. This is a case where the Commonwealth's evidence against this defendant was overwhelming. In addition to his own confession to felony murder to the Lowell police, which I already addressed, you also had the testimony of the two cooperating witnesses that he, Christopher Middlemas, and the two of them armed themselves with the guns from Colin Federer. They masked themselves. They obtained a key to the defendant's apartment in order to break into his apartment and steal from him. They went upstairs, and when they didn't find money there, they decided they were going to lie in wait for him to come home from the bar so they could rob him at gunpoint. That's what the evidence from two witnesses was. And that when, in fact, that went awry, the defendant confessed to those two individuals that he and Christopher Middlemas had shot the victim during the course of a struggle. Furthermore, there was also ballistics evidence that cartridge casings found in the victim's apartment were matched to Mr. Federer's guns, and there was cell phone evidence that corroborated those two cooperating witnesses' version of events that demonstrated that the defendant was in fact in the locations he said they were in, they said he was in, at the time of the murder and following the murder. So, Your Honor, I would suggest that there's absolutely no likelihood of a miscarriage of justice in this case, and I would ask the court to affirm the defendant's convictions for the murder of Alberto Cintron in Lowell on July 4th of 2006. Thank you.
Thank you, Counsel.
All rise.